With prejudice to my time limit, which my lords have given, just an aside, my lords, I'm reminding myself of being that apocryphal son-in-law or Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said, whatever he's able to lay his hands on. That my lords, seems to be my position in terms of, my lords, both time and submissions to really...
So what are the key submissions?
Key submissions, I'll refer to this, my lords. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. And the reason why I'm making the submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jethmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India is applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. 35A introduced, my lords, by constitutional order in 1954, CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, Manoj.
People who came from the Pakistan occupied Kashmir,
yes,
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residence as defined in the Act is any citizen of India but subject to 3 important riders. Rider number 1, the person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2, he must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That therefore, my lords, meant that even those who were there citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only...
Other parts of the country.
Yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my lords?
You're saying the other way around.
No, may I show 6, my lords? Can I show 6?
Well, I'm sorry to interrupt. There are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, well, all that is fine, but that's not to be decided by your lordships. If this is upheld, if what the union is saying is upheld, this is unnecessary.
All these are persons.
They've been applied, treated as cumulative.
Yes. You are outside Jammu and Kashmir. You don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3.
Yes.
subsection 3.
Yes.
Namely, that refers you to
1927.
So
That's right.
you're out there.
Yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by Clause 3 of Section 6.
no, my lords, what will happen? They will be governed by Clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of Class 1 or Class 2, and you should have been holding property.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Kishore, I don't think 2 can be read as cumulative because it imposes a condition of owning a movable property.
No, I follow.
That owning property.
No, I understand. But the fact of the matter is,
It cannot be.
the fact of the matter is, my lords, they were entitled, but they have not been provided. That's the factual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
Get documents of 1927 will be very difficult for anybody.
That's another aspect, absolutely. I bowed on to that.
Now, in Clause B, prior to that date refers to which date? 14th of May, 1954?
Yes, that's right. 1954. That 14th of May, 1954.
Yeah, for Clause A, subsection 3 applies.
That's right,
There
27.
is a 1927 order.
Correct.
For Clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I bowed on. And that
So
date,
anybody from 14th of May 1944 onwards
that's right.
comes within the
Should
purview
have
of
held property, and that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because
Yes.
to say that you must own a property to get citizenship.
Exactly. Now, one more thing, my lords. One more aspect, my lords. Please have a look at 2, section.
You're really trying to say is you're supporting the CO 272 and 273
Correct.
by pointing out the anomalies which would otherwise arise as a result of Article 35, Section 6 and 35.
I bought on the challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has
It stands. But
kept aside.
I bought on, my lords.
An application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I bowed on, my lords, but then I am saying that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my Lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of Class 1 or Class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan, returns to the state under a permit for resettlement in the state of a permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than
POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir constitution makes provision for seats for POJK in the assembly, but says because it is under. That's why. Now there are 2 other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling my lords with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1. Now, 31B, my lords, under the constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of part 3.
Guru, now I also note that in your written submissions, you have really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective.
That's right.
I think let's go into the next.
Three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in COILO, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in COILO. Now, ultimately, my lord said, you cannot take away judicial review, and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge, and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part. Ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the ground norm. That's the touchstone on which any constitutional decision-making has to be considered. The validity of any constitutional decision-making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions.